It was about a year ago that 32-year-old Bailey McCort was assaulted and murdered on a busy section of Highway 97. Her attacker was a former partner. He was out on bail, and her death sparked a national conversation, created outrage in the community, and her family called for change. And that change did come recently. To explain it all, we have with us Debbie Henderson, a spokesperson for the McCort family, and our very own legal counsel, Tyler Fulkerth with Benson Law. Before we get started, I just want to say thank you for being here. Thank you for the strength to speak up. And it hasn't been an easy fight for you. We do try and chat the show to bring about conversations in the community that are relevant and important. And I also want to say at this point a big thank you to Benson Law for sponsoring this episode, because this is so important for our community. It's important we talk about it. It's important we learn about it. So thank you, Benson Law. Debbie, tell us about Bailey.
Bailey was a 32-year-old mother of two. Her father is my brother-in-law, so I've known Bailey for 6 years. I would meet with her when she was at my sister and brother-in-law's house, and you couldn't help but be gravitated towards her. She was very extroverted, very quick-witted, and wasn't afraid to share her thoughts or opinions.
How long was she with the person who was charged with her death?
I think probably roughly around maybe 6 years or so. They'd only been married, I believe, for about 3.
And was it a tumultuous relationship, a one that was fraught with trouble, or was it something new?
I think it progressed to that after they had gotten married. There were certain signs, like he seemed very frugal with finances, and I think retrospectively it sort of seemed like a way of control. So,
and that's all that is part of this change in legislation. Tell us about the journey to get this change, and why was it so important? When things like this happen, families call for change, etc. But not everybody takes it to that level as you did. I mean, you've been in and out of Ottawa.
Yeah, I think with our family, there's a lot that happens when someone's murdered. Bailey's vehicle was hit by her ex-husband. So you look at ICBC's involved, then you have to look at a state in terms of my brother-in-law sort of managing Bailey's estate and figuring out family law and the children. And there was a big component of Bailey shouldn't have died. We all knew that. Bail is for those that have been presumed innocent. Her ex-husband was not innocent. He was found guilty that day and released. And 3 hours later, he murdered her. And I don't know how that wouldn't spark outrage. And in our family, that's something that our family decided that I should take on in terms of media and political angle. So I think with that, you couldn't help but be angry and know that change needs to happen. Ideally, we would also like to see Bill C-75, which is a bill implemented in 2019, which has the provision of restraint, which instructs a judge to release a perpetrator at the earliest opportunity with the least amount of restriction. And I think that's what we saw in Bailey's case. And we haven't gotten there yet. It's a bit of a challenge. We've brought it up numerous times, brought it up in committee meetings, as well as MP Frank Caputo had a private member's bill that he had actually started to draft the previous year, but didn't have a chance to table it. And when Bailey was murdered, he added in that component of presumptive first-degree murder, which has now been changed in the committee meeting to have the element of coercive control in it. And I reached out to him and spoke with him about working together and if he would consider calling it Bailey's Law, and he was honored to. So during that process, I met with Frank quite a few times. I was asked to participate in committee meetings in Ottawa. So I went to those, and politics is a whole new language. So it's been a challenge to learn, but there were great people along the way that would answer my questions and explain things to me, and we just kept pushing. There was absolutely no way this bill was not going to go through. And even the last time I was in Ottawa, when it reached the Senate, I went out and I was only going to be there for 4 days, but ended up staying the full 2 weeks to ensure that this bill would pass.
I salute you for all your efforts. I'd like to drag Tyler into this. Tyler, can you unpack it all? I mean, it's a lot for someone who doesn't understand the process to take in.
It's a lot. Debbie, thank you. It's a pleasure having you here to speak with you about this as well. What you have been able to achieve in such a short period of time in the legal world is extremely fast. In the legal world, things don't move as quickly as they do, especially with the implementation of various amendments to the Canadian Criminal Code here. And specifically, just so we're aware, this is Bill C-225 that's made various amendments to the Canadian Criminal Code. Those amendments take full effect within the next 10 days. So I applaud you. That's not an easy feat. What I can advise is Bill C-225 does the 4 following elements, and I'll just refer to my notes. So it creates a new specific offense of murder in the first degree for intimate partner violence. It requires the courts to consider life imprisonment with parole ineligibility of 10 to 25 years when manslaughter is committed against an intimate partner in the context of such a pattern of intimate violence or coercive control. It creates a new offense for violent, threatened, or attempted violence against an intimate partner. And the last one is extending the maximum period for detaining seized items, so evidence, under Section 490 of the Act for 3 months up to 180 days. I believe I got the salient points with respect to the bill. But not only that, this is a grassroots movement. So it started, unfortunately, because of a sequence of events that occurred on July 4th of 2025. Again, my condolences to you and your family. But the way that this moved is going to significantly impact the Canadian criminal system for sure. The impact of these changes are yet to be felt because we don't know of any cases that are going to be reported on this. It's going to take some time. There's going to be several cases that are going to be tried with respect to this, with intimate partner violence, but it's also changed the way that family law has worked. And I believe I alluded to you earlier. The Supreme Court of Canada just recently issued a family decision, and hopefully I got the pronunciation right. It's Ahluwalia 2026 SEC 16. It's a decision in May of 2026 this year that where the Supreme Court of Canada determined that a new tort for intimate partner violence could be something that could be advanced by an individual in a family law dispute. So these are, in such a small period of time, monumental shifts, and you're certainly part of it. And again, just to bring that into perspective, these things take often years, sometimes decades, for these changes to take into effect.
And political will.
Well, not only that, it's just not only political will, but my understanding is once I've read some of the Hansard and some of the first, second, and third readings, this was almost accepted by all parties, bipartisan. So
how could you not, though, Tyler? I mean, it would be morally repugnant if they didn't.
Yeah, and I do believe that this is one of those things where the government and just society in general, now the Canadian society is trying to protect individuals, trying to protect individuals that are in relationships that they can find themselves in. Often at times we don't move quick enough to protect against family violence or intimate partner violence. Obviously each situation, each relationship is contextual, and it's specific on what happens in those types of relationships. But reading statistics, and just recently read a BC coroner's report, about, on average in BC alone, 15 deaths are due to intimate partner violence.
So if I were to condense it down to what you said
Yeah.
in non-legalese, the outcome of what we're talking about is one person is automatically sentenced to first degree. No ifs, ifs involved. Secondly, no parole for 20 to 25 years. Thirdly, the coercive component. Could you speak to that? That is to see that it's illegal now to sort of control, get into their phones, find out where they're going, what they're doing, who they're talking to. Isn't that all part of it? That's part of the of what they could be that could go against them.
Yeah, so I'm more or less speaking about a family law perspective more than a criminal law perspective, because they will be treated differently at law. However, like if you look at intimate partner violence or family violence for that matter, coercive control is certainly one of the elements that the court will take into consideration when they're establishing whether a protection order needs to be granted.
So, so just explain what is included in that. It's
Yeah, great question. So coercive control can mean a plethora of things. So it could be financial control, it could be emotional, mental, psychological, physical violence. You're starting, I've seen quite a few cases whereby it's financial control and psychological. So there's no actual physical violence, but the other person is coerced through emotions or psychological, and then all of a sudden their spouse also controls the finances. So they really are left helpless and hopeless, effectively, if I can say that correctly. But yeah, that's the situations that you see in a family law context. And what I project moving forward based off of the amendments to the Canadian Criminal Code, those factors will be brought into consideration for sure.
what's the fourth one? I missed out on that one.
So coercive control could be
No, after coercive control, there's a fourth factor into this.
extending the maximum period for detaining seized items, so evidence. For example, a mobile phone is a prototypical example. So I assume what you'll see in the future is, again, I don't practice criminal law, but what I assume in the future is you're going to see the RCMP or police authorities, the equivalent there to keeping like a person's cell phone as evidence. And they'll be able to go through their cell phone or through particular items instead of 90 days for 180 days to go through.
Right away.
Yeah, because what they're likely going to establish from an evidentiary perspective is to see what sort of control through text messages and otherwise that they could use potentially to prosecute these charges.
There's another element actually that is part of the bill, and it's basically naming assault. If you go to Walmart or a bar and somebody assaults you, it shows up as assault. But if you assault your intimate partner, it also shows up as assault in the system.
Okay.
And that's also been changed regarding intimate partner violence.
Right.
So it will show when a police officer pulls up a record, they will be able to see that there was an assault related to intimate partner violence.
Yeah.
That was also.
So that separates it from just a generic assault.
Yeah.
I mean, in all due respect, I think that will help in a family law context as well, because most family lawyers will be able to get the criminal records and those charges or convictions, and they'll be able to see that it's actually intimate partner violence as well. Yeah.
I have a couple more questions, Tyler. You might think they're unfair, but will this change stand up in court? I mean, it's not tried and tested yet, because it's pretty harsh to say first degree bingo. If it is one of emotional violence, not that I'm saying that's negating that, but if, say, in a violent outburst there is a murder, would this stand up in that case? Like, I'm just saying, could this just sort of be nice words, heartwarming, feel good, we did something, But will this stand up in court?
That's almost impossible to give you an answer about that at this current juncture, because we haven't seen the full impact of how this law will apply in the future, right? So I can't give an answer to that at all. What I project will happen is that this will be tested in courts across the country, criminal charges, and this will be tested throughout the respective courts in every province. And you're going to get various decisions that will be different from one another. You'll likely get tests that will that the courts or the judges will utilize in order to determine whether it passes a particular threshold. I assume that's what will happen in the future. But right now it's too early to tell. But I don't think this is one of those things where it's heartwarming. This is serious. This is extremely serious, and I think this will, depending on how the cases roll out in the foreseeable future, I really do believe that this is a monumental shift, and a monumental shift in a short period of time.
Very short period of time. Now, this is a very unfair question to ask you, and you might want to might say that it's unfair. Right. Had this been in place, would Bailey be here today?
Again, I don't practice criminal law in particularly, but if the laws were a lot stricter with respect to bail reform and as Debbie, as you said, that he was convicted and then subsequently released, if these laws were in place, chances are the individual wouldn't have been released. And if the individual's not released, chances are Bailey's alive.
You also talked very briefly about compensation for, I wondered if you could, is that legally enshrined as well? Can you speak to that?
So again, yes, this is dealing with a tort, so it's a negligence claim on one end, but the tort would be effectively intimate partner violence in a relationship between two spouses. And so it'd be some form of compensation, so a monetary award to an individual that satisfied the test on the balance of probabilities.
And who determines the amount?
Great question. Still in its infancy, would have to see further cases move forward, but it'd be a justice that would determine that at the British Columbia Supreme Court level. Yeah.
Debbie, I just want to ask you how your family's doing. Is there a sense of huge relief now you've reached this point, or are you still watching and waiting to see?
I think this eases some of the weight of what's happened, knowing that change is happening. This bill isn't the be-all, end-all. There's so many, it's multifactorial when it comes to intimate partner violence, and there's so much more that can be done and can be implemented. For example, I've been working with our local MLA to push to have GPS monitoring with geofencing and mobile geofencing.
What is geofencing?
It's an alert system where within a certain perimeter, let's say around your home, school, work, where if an individual with let's say an ankle monitor goes within that zone, we want to see real-time alerts going to the victim so that they know.
Oh, I see.
In Bailey's case, she had no idea that her ex-husband was waiting for her in the parking lot. If there was GPS monitoring, she would have been aware. She could have decided to drive away from that area, call the police. It gives options. And I've been doing some research specifically in Spain. People within this program, it's 98% effective. So for me, I look at that and why aren't we implementing it? It's actually not that much of a cost when you compare it to each individual life that's lost in a violent crime. Immediately, that costs the system $400,000. Then you look at even the bigger picture, when her ex-husband is found guilty and goes to prison for 25 years to life.
On bail?
And he's going to end up, it's going to cost the system roughly $5 million. I hate to talk about money, but unfortunately our system is designed where the government is constantly saying, oh, we're in a deficit, oh, we don't have money for that. Well, there's a cost savings here, a substantial one, and it's minuscule with how much it will cost to implement the GPS monitoring. We also want to see mobile alerts because no one should be confined to their home, work, school, and not be able to go out. Everybody who knows me and in my life, they know where I bank, they know where I grocery shop. So you better believe somebody's intimate partner knows those details.
Correct.
So I think it will allow, and I've spoken at many roundtables and with survivors that are currently going through it. And as soon as I started talking about it, there was like an audible sigh, like, oh, I could have some sense of peace and not have to be so hyper vigilant constantly, because they say to me, I don't want to be another Bailey, and we don't want that either. Yeah. So we're going to continue to advocate and fight for further changes because they're needed.
How are her children doing?
Her children are doing okay. The youngest one she's so little, I think it's not something she can comprehend. And the older one, I don't know the details.
Thank you very much for being here, Debbie, and giving Bailey a human face to a very complex legal issue. Tyler, last word to you. Will this stand the test of time, you think?
I think it's going to be tested. Will be tested in the criminal courts for sure. I'm interested to see what the impact is from that moving forward from a criminal perspective. I anticipate much like any other thing in the Canadian Criminal Code, it'll be tested and it's fact-specific, evidence-specific as well. But I just think it was just this is very unique. We sometimes fail to comprehend that as individuals ourselves, we have the ability to start a movement. And this is one of those movements where I think has made some significant changes. As to the full impact of those changes from a legal standpoint, yet to be determined. Yeah.
The language used is strong enough?
I believe so. But again, you have to look at the thresholds that have to be satisfied in a criminal context in comparison to, in a civil context. So we will see in the coming months and in the coming years what specifically, how much teeth Bill C-225 has and the amendments to the Canadian Criminal Code. Yeah.
Debbie, your family took the lead on this, but society followed you, and this was a tidal wave and a change for the better. And we'll see what happens going forward. Hopefully there is no other Bailey McCort and no other incident like that. Thank you both for talking to us. It's important for us to have these conversations. And thank you to Benson Law for supporting and sponsoring this podcast. And thank you all for watching. I hope you learned something. Take care out there. From all of us here at Chai and Chat, bye-bye.